Now, the main area where the DA and I disagree is about the sentencing, and I think that's because we're both looking at rehabilitation. Obviously, Mr. Dent's rehabilitative needs are fairly great because, you know, he's battled a long period of substance addiction. He did have a period in between where he was clean. He did successfully complete a 10 years of probation. It did say revocation, but it was a 17-day revocation. It mentions that in the PSI. So it's not like he was revoked and sentenced for 9 months or 2 years, et cetera. It was, you know, what we would normally think of more of a sanction than anything else. He was discharged from that successfully. His 2018 case, he successfully completed his 2 years of probation. He had some difficulties. It mentioned about appointments. It mentioned, you know, bringing in materials, and Mr. Dent can talk about more when it's his time. But one of the things he's let me know is that, you know, he was in special ed and his reading is probably on the 2nd or 3rd grade level, and that his daughter had to read some of those things for him to do it. So it wasn't like some people where they just choose not to turn things in. He has reading difficulties that make it harder for him to read and write some of those things. Now, the other thing that's sort of unique about drug addiction is that it sort of turns our idea of specific deterrence around. You know, addicts have, you know, when you're addicted, you know, we think of deterrence as a rational thought process. You know, if you're not functioning, you know, suffering from addiction or some sort of mental delusion, we understand deterrence, that if you do X, you'll get Y. If you do X again, it'll be worse. When you're dealing with addiction, that thought process doesn't really apply. So I don't think the idea that, well, X deterrence didn't work, so this time we need X times 1.5 as specific deterrence really makes sense. Because deterrence applies to when you're thinking straight, and when you're, you know, suffering from an addiction, the last thing you're doing is thinking clear-headedly. Now, the other things like talk about when we're talking about rehabilitation is, you know, some of Mr. Dent's life has changed since in some of his cases. I think when you look at the PSI, it shows that up to around 2012, for the most part, you do have, you know, more of a personal history that involves violence. He appears to have aged out of that phase of his life. Because I know one of the things when they recommended, you know, 8 to 12 years of, 8 to 15 initial incarceration and 4 to 5 extended supervision, one of the things they focused on was a prior history of personal violence. But if you look at his conduct since, you know, say 2010, you can see that conduct is, you know, fade out of his life, especially since the last decade. And that's even factoring that, you know, when he was arrested in 2018, he did plead to attempting to take a weapon from a law enforcement officer. But even if you include that, it's still a lower level than when he was a younger man, and violence seemed to be just, you know, a part of life. Along with the rehabilitation we talk about that they can get, I think when you look at his daughter's letter, the letter from his ex-wife, you see something important is that there's, you know, more of a motive. He has some motivations to pursue rehabilitation. He has reasons not to come back before the court.
I'm just interrupting you right now. I don't have a letter from an ex-wife.
Oh, PO. It should be in the exhibits.
And what exhibits? I don't get exhibits for this until it's received. And then I don't get exhibits until far after it's received in court. So if you filed it as an exhibit, I have zero access to it.
Okay, I'm just trying to, I mean,
To talk to CCAP and get that changed back, I would love it.
okay, well, I have the physical copy here of the letter from Paula Olson, if
All
that
right.
works. And
Have you seen it, Mr. Schmidt?
Oh, okay.
Yes, so you know, and I tell all of the attorneys that are in front of me now, we don't get exhibits until after you say, Your Honor, we received this, and I say received. And then once I say received, it still takes 15, 20 some odd minutes for the system to recognize and get back. So I don't usually get it until after the fact.
Okay, well, like to enter exhibit.
So you should know that for every other county. And if you are going to file things, even if you are going to use them as an exhibit in your hearings, I would file them as just regular old documents and then, or proposed exhibits under a document, not under an exhibit. All right, so let me read this really quick.
Sure. No, in that case. I suppose you didn't get his blood sugar levels either.
I got that one.
That one
don't
came
know.
through because you asked for it to be sealed and you attached it to that motion.
Sure.
When things are attached to a motion, they come through.
Okay. I'll make sure.
So that's just food for thought for any other case you have in any other county.
Okay.
All right, I've reviewed the letter. I am now going to give it to the clerk. All right. Now the letter I have reviewed and I've heard Ms. Den's character statement.
Okay, and there I am going to refer to is just, I have 4 certificates of completion for parenting education. I'll present them to the.
Is he taking parenting education to parent his grandkids?
Yes. I was confused by that. Yes, I was confused by that at first because look at his age, like, well, either you're Anthony Hopkins and we just didn't know it, or oh, we thought that someone was 81. Okay. All right. So as I was saying before bringing the exhibits, I think when you look at someone whose crimes are primarily motivated or, you know, addiction related, I don't think that focusing heavily on the specific deterrence is necessarily useful. Now I'll deal with the, and that proportionality, again, we're not dealing with someone who's in a rational state of mind, not insane or anything, but just, you know, addiction, that whole rational thought isn't there. So I don't know that proportionality necessarily makes sense. Okay. But Mr. Den, according to the PSI, you know, did succeed on probation, even with some hiccups. And that was during COVID probation where most of it was virtual. And I tend to have the same skepticism of virtual probation as this court tends to have about signature bonds. That, you know, unless you can see the probationer on a fairly regular basis and see if, you know, what services they may need, or if they're lapsing, you know, a Zoom has its limits. But despite that, he still made it through, and he did end up having to go in once a month because with his reading difficulties to go over things with his agent. So his agent did, within the ability of limitations of COVID, you know, provide supervision. But those things show that, you know, when he's monitored, and the PSI said the same thing, that when he's monitored, it he tends to do better. And that, oh yeah, there it is, page 27, where it says he continues to repeat the same behaviors when there's nothing to hold him accountable. And that's on page 27. I would suggest that, you know, there's some built-in accountability with time in jail, and I'm
Anything on page 27? Because my 27 has recommended, where it has sources of information.
okay.
You're talking about the PSI, correct?
Yes,
I do recall what you were
Okay, then-
stating.
yeah, okay, then then strike the page part
Under
of
a
it.
watchful eye, he behaves better.
Yes. But along with the coercive elements of probation to keep him on, is to try and keep him on the straight and narrow. His daughter and his ex-wife have talked about, some of the motivations to succeed on probation is that, he does have, grandchildren who need him. He does have his house that if he's sentenced for a lengthy time, will, when he gets out, he'll pretty much be a homeless man. He did show that he has successfully completed before. And it does show that, for a man who was, in younger days more violent, they both mentioned examples of where he's trying to help members of the community as well. And I'm not saying to minimize the drugs that were shared, because, we recognize that drugs, have been a scourge to the community, whether people take them or, hunt them down or not. But he does have more motivation than most of my clients because he has, or it was like most of my clients are right before me aren't this old. They don't tend to have the family members who rely on them, and they don't have the assistance available. And they also don't have the track record that when they are monitored, they can actually complete probation.
All right, let's talk about that. Defense attorney Glenn Keene's closing argument in State of Wisconsin v. Michael Dunn was a measured counterpoint to the prosecution's earlier push for a lengthy sentence, and it leaned heavily on the human side of Dunn's story. Keene opened by noting that the core difference between his position and the state's was their approach to sentencing. The prosecution, he argued, was looking almost exclusively through a deterrence lens, while he believed rehabilitation should be the focal point. Keene acknowledged that Dunn's rehabilitative needs were significant. He pointed out that while Dunn's criminal history was lengthy, there were bright spots, long stretches of sobriety, a completed 10-year probation term with only a short 17-day revocation, and a successful 2-year probation in 2018. Some of Dunn's struggles with probation requirements, he explained, were tied to literacy challenges. His reading level is at a 2nd or 3rd grade level, meaning even paperwork often had to be read aloud by his daughter. That detail reframed some past compliance issues, not as willful defiance, but as genuine difficulty. On deterrence, Keene made a broader point. Addiction doesn't operate on the same rational calculus that deterrence theory assumes. If you do X, you'll get Y doesn't land the same way for someone in the grip of substance dependence, he argued. That's why simply increasing the severity of punishment after a past sentence failed to deter might not actually change future behavior. He urged the court to consider that logic carefully before doubling down on incarceration length. Keene also addressed Dunn's past violence, noting that while the pre-sentence report referenced it as an aggravating factor, the bulk of it was over a decade old. Since about 2010, Keene said Dunn's conduct had shifted fewer violent incidents and more stability. Even the 2018 charge for attempting to take a weapon from a law enforcement officer, he argued, was a lower-level offense compared to Dunn's younger years. The hearing had an unexpected procedural hiccup when Keene referenced a letter from Dunn's ex-wife, Paula Olson, only for Judge Mogen to clarify that she hadn't received it yet because of how exhibits are processed in the court system. After a quick back and forth, the judge reviewed the physical copy and confirmed she'd heard from Dunn's daughter as well. There was even a brief moment of humor when Keene presented certificates from a parenting program, prompting the judge to quip about Dunn's age before clarifying they were for his role as a grandparent. Keene's final points tied the rehabilitation theme together. Dunn has motivations other defendants often lack: family members, including grandchildren who rely on him, a home he risks losing with a long sentence, and a demonstrated track record of better compliance when closely monitored. He didn't minimize the harm caused by distributing methamphetamine, but he framed Dunn's case as one where structured probation, accountability, and family ties could yield better outcomes than an overly punitive approach. Through it all, Judge Mogen maintained her calm, attentive demeanor, making sure procedural clarity was met while allowing each side to fully present its view. The atmosphere stayed respectful even in moments of disagreement, which kept the focus squarely on the central question: what balance of punishment and rehabilitation would best serve both the defendant and the community? If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.